So in this lesson, we want to get into estate planning. Now, it's interesting because most people, when you tell them estate planning, if they know what it is, they think about, oh, when I die, when I have my multi-millions, and we want to tell you today, no, estate planning is not just for, yes, it is for that group of people, but it's not just for that group of people. Right. It's for everyone and anyone that has assets and loved ones, and that combination creates a need for estate planning. That's right. Is that a fair statement? So first, we want to recommend that if you've done financial planning with us, you pull out your trail map. Now, the trail map, again, is high level, so you'll see here, it'll tell you whether you've done appropriate estate planning on your trail map on the bottom of the foundation side, as you see on the screen.
Just to make sure you have your will and certain documents.
And some of the documents that we're going to go into. Now, if you haven't done a financial plan with AllGen, that's okay, because you'll still learn from this lesson what you should be doing for yourself and your loved ones as far as estate planning and how it relates to you. So you don't need a trail map to really benefit from this lesson.
Right.
Now, that being said, disclaimer, AllGen Financial Advisors does not provide legal advice. The information contained herein is of general nature, and you should consult an attorney to assess your particular circumstance. So, there's my legal disclaimer voice. Hopefully that was a little bit humorous. But, yes, we're not attorneys, but we know enough to collaborate with attorneys and recommend that you get an estate plan done. So, what is an estate plan? So, an estate plan communicates your wishes to loved ones in the event of your death or incapacitation. And that's the key that we want to bring up. It's death or incapacitation. So you may not die, you may still be alive.
Yeah, a lot of people don't think about that.
Right.
They just think about the dying part.
And we're going to give some examples of that in a minute, okay? But an estate plan allows you to have control over your affairs, even when deceased or incapacitated. You've seen we've heard so many horror stories of the estate, the loved ones having to deal with a mess after someone passes, or after someone becomes incapacitated. That's the purpose of an estate plan, to help you avoid that.
Yes.
Okay, leaving
it's a very
a
loving thing to do for your
It
family.
absolutely is. And ensures your assets are transferred to the right beneficiaries as you intended them to do, to be. So why is it important? Critical piece of managing your risks and financial affairs. It, again, allows you to provision for loved ones who may be financially dependent on you. Okay, so it allows you to provision for them, and to do so in a neat way that's organized and not create a headache in a time that's typically full of anxiety and grief. Okay, and it helps you avoid costly or unintended outcomes from transferring assets upon death. We're going to talk about this, for example, probate. So it could help defer some of the costs that your heirs may incur otherwise. Okay, so that's why it's important. So here's some forms that, again, we recommend you get this done with an attorney. And we'll say this a few times because there's a lot of legal ease and jargon and language that's necessary in your estate documents. Right. But when you get an estate plan, you're literally getting physical documents, okay, that come, it's usually a very thick package that cover various different areas of your financial picture. One of those documents is a will or a trust, okay, depending on what makes sense for you, and again, consult an attorney for your particular circumstances. But the will or the trust is usually the bulk of it, and it expresses your wishes on how you want your assets transferred at death. Okay, it's what most people think of. Oh, I don't have a will. Well, you know, if I die, yes, this is that piece of it. Okay, so it designates guardian for your children. If you have children, especially if you're a single parent. And something happens to you, who do you want to be the guardian of your children? If you don't designate that, it's really up to the court. You're telling the court, you decide.
Right.
And then if you have families, you know, mixed marriage, it can get really hairy. Okay, so this part allows you to designate who you want to be the guardian of your children should something happen to you. Okay, and then it names the executor for your estate. What is the executor? The executor is the person that's legally responsible for carrying out your wishes as delineated here in the will or trust. Okay, so you've heard horror stories, you've probably seen movies about it, you know, people fighting family members, and you know, again, I wish this to never happen. Unfortunately, I've seen money do funny things to family members. Okay, we've seen it. Okay, so or friends. The will or trust delineates who you trust, okay? And you should tell this person ahead of time.
Right, you don't want to keep this thing a secret. So
Right.
a lot of times people don't talk about this stuff.
Right.
You know, I really think, and we really believe, families should have these discussions.
Right.
You know, I know people have this taboo that if they talk about dying, they're going to die.
Right.
Well, let me tell you, you're going to die. There's a 100% chance that will eventually happen. But if you communicate this with your family, it's not a surprise, and they can be prepared for that, and they can know where your documents are. They can know where certain things. They know what to do. So it's important to have those conversations.
That's exactly right. It's about being organized ahead of time, because after the fact, it's too late, right? You can't do it, and then that's when you leave people running around trying to figure everything out. Okay, so that's your will or your trust. That's going to be the first document when you go get an estate plan done, drafted up with an attorney. The next area that this package should have is a durable power of attorney. Okay, now the durable power of attorney is interesting because the laws have changed over the years as far as limited power versus durable. So what you need to understand about this is the durable power of attorney designates someone to make financial decisions on your behalf, okay, while you're alive but incapacitated. If you ever are put in a situation where you can't make financial decisions for yourself, accident, illness, etc., you empower someone, full authority, to make those decisions on your behalf. Okay, now that's important and scary at the same time, because you literally are giving someone the authority, the power to manage your finances.
Yeah, so it needs to be someone you really trust.
Absolutely. Absolutely.
And it has some bit of knowledge about finances.
That's right. So this person, the designated person, is called a principal, will have full authority over your financial matters. So again, as Jason mentioned, it should be someone that you trust and that hopefully aligns with your philosophy of finances, and and is capable of doing this. Okay. So that's another person, another piece of the estate planning package that will be delivered to you when an attorney completes this.
No, I'm just going to say, naming a durable power of attorney is not necessarily, it's not a benefit. It's different from a beneficiary.
Right.
Some people may confuse that, but it's just giving someone the authority to be able to handle your finances at a time where you could be incapacitated.
That's right.
And we probably all know friends or family or have been through the situation where maybe one of our parents is in a position where they can't they can't handle their finances.
That's right.
Whether it's dementia, Alzheimer's, something like that, and it's important to have the right person handling these affairs.
That's exactly right. I had one of these done personally when you said family, when my aunt has dementia. So she trusted me before she had dementia. We had this conversation, and her son my cousin lives in California. So, we talked to him, and he was cool with me, since we live closer together here in Florida, that I'd be able to manage this, on his behalf and on her behalf. So I had the durable power of attorney drafted up, for an attorney. So by an attorney. So that's the durable power of attorney. The third piece that should be addressed in an estate plan is what happens. That's the financial side. How about the health side? Okay, and this is what's called the healthcare surrogate and living will. So it concerns with medical treatment. So the healthcare surrogate you get to designate someone to make healthcare decisions on your behalf. Do I operate? Do I not operate? Some of you may have signed this if you ever had someone you cared for in the hospital, or you went to the hospital, say, hey, if something happens, the hospitals have a form there for you to sign.
Right, and they check them when you go in.
Absolutely, because it's a legal document.
Right.
They're liable if they allow the wrong person to make a decision on your behalf. Okay, so but it's a lot cleaner, quicker, and easier if you already have one.
That's right.
Okay, and the person who you've designated knows this, because the moment they know something happened to you, they can show up, or they can communicate with the hospital, say, I'm the healthcare surrogate, here's what I want to see happen.
Yeah, and it's important to know where you keep that document.
Absolutely.
Because you never know when someone's going to get hurt or something where you need that immediately. A lot of hospitals will actually accept a digital copy on your phone.
That's right.
So if you store it in your phone somewhere, you can literally show them on your phone, and you're good. But know where it's at.
Yeah, you should know where it's at, and the conversation to think about whoever you designate should know where it's at and have access to it, because you may not be in a position to actually show the doctor, okay, but you want that other person who has the authority to show it for you. So again, planning ahead of time. And so that's the healthcare surrogate piece. Do I operate or not? The living will, this is a touchy situation, but this is the person that allows your wishes. Typically, do I pull the plug or not? That's the common language. It's the person. Do I use respirators, things to keep you alive artificially or not?
And for how long?
And for how long? You can actually predetermine that and authorize someone. Could be the same person as a healthcare surrogate, okay, or not, but this is another piece of your package, your estate plan, that you want to have ahead of time. There was a very famous case and I say famous case, unfortunately, because of the drama that was created here in Florida. Terry Schiavo. This was years ago, and
went all the way to the Supreme Court.
It went all the way to this poor woman was in a coma, okay, and she was living by artificial means, okay, and the husband wanted to, quote, pull the plug, okay? Oh, but mommy and daddy, Terry said, oh, no, that's our baby. There's no way you're pulling the plug. Became a legal battle. Hundreds of thousands of dollars spent, okay? And Terry, who should have the most say in this, unfortunately did not have her estate plan in order. So it just costs a lot of money, a lot of angst, and all that kind of stuff. You can avoid all that by being prepared ahead of time. Again, not a lovely, optimistic subject to talk about. And again, I'm all about living, but it's also good to do it for the benefit of someone else, not leave a headache to your loved ones.
Yeah, there's just a level of peace of mind when you have these things in place. You know, I mean, it's not that it's fun when you're doing them and getting them all in order. That's not fun, but it is just nice when it's like, oh, I have that done. Great. My kids have a guardian. I have the healthcare story, living will, simple everything. You know, we had the discussion with the family. I mean, it's just there's just a level of peace that comes when you have that all done.
That's exactly right. So we've talked about these different documents, and as I said, most people think about estate planning when you die, but here's a nice little chart that shows the summary of which documents relate to different circumstances. So if you're alive but incapacitated, the durable power of attorney might kick in, the healthcare surrogate might be necessary, and the living will, okay, pull the plug or not. So these are documents that are essential in an estate plan if you are still alive, okay? Now, if you do pass, okay, the last will and testament should be part of that package, trust if you had one of those, and probate, and that's not a document, okay, but what happens if a lot of the reason behind this is to, again, we talked about transferring assets to your heirs in a clean and hopefully cost-efficient way. If none of this is done, upon dying, your estate will go through probate. And probate can be a very annoying thing. What happens when you pass away, if there's no joint owner on the account, everything gets, an estate is created, okay? So that's, all those assets are frozen until the court determines who is the appropriate person to get them. And I've seen that last 2 years.
So what happens if you have like a TOD on your account? Does that go through probate?
Well, that's one thing we want to talk about. I mean, when you look at this is what happens in the probate part. Look at all the steps, okay? First, your will needs to be authenticated, okay, last will and testament. Then the executor has to be recognized by the courts, okay? There may have to be some bond that the executor has to do, which basically it's insurance in case the executor goes rogue, okay, to make sure no one, your beneficiaries don't lose money. Then you locate the decedents of the assets, determine the date of death, the value of your assets, identifying and notifying who the creditors are, paying the decedent's debts, preparing and filing a tax return, and then finally distributing. That's a lot of steps to go through, okay? I'm not saying you can avoid that. Again, consult an attorney, but it'd be nice if I can get my, and I don't mean this in a wrong way, but if my parents pass away, I don't want to have to go through all this nonsense if I can avoid it. Because all this costs money, okay? And the executive, your probate, an attorney that gets assigned to handle your probate can charge anywhere 3 to 6% is a typical range that we tell people of the whole estate. So that includes your value of your home, that includes your accounts, everything. They can take 3 just to make this happen. So I've seen people pay $45,000, okay, just to have someone say, okay, you get this, okay, you get this, where if you could have paid a couple of thousand up front, some of them may have been avoided, okay? So you want to avoid this mess. Again, peace of mind for the loved ones you leave behind that already are going through grieving and all that type of stuff. So to get back to your question, you can avoid some of this simply by changing the titling of your accounts, okay? Again, this is not advice, but a consideration that you should bring up to your attorney. But you can, let's say you want someone to inherit this, you can make them a co-owner. Now be careful, because if they're not your spouse, there might be some estate tax issues and all that type.
You have to be very careful.
You have to be very careful. But you can ask your attorney, should I be retitling some of my assets? In fact, in a lot of estate plans, retitling is part of the plan. Your attorney would tell you that, and you got to make sure you do retitle the assets, because you can have all these great documents, but if you don't retitle, it's just a piece of paper, go for nothing, okay? Another strategy some people use is assigning a beneficiary designation onto an account. So you can go to your bank and say, I want to add a beneficiary to my account, or what's called TOD in some cases, depending on the institution, but they know what you're referring to.
TOD stands for transfer on death, and sometimes it's POD, payable upon death.
Payable on death, right. So what that does is it lets the institution know who the beneficiary is, even on a bank account. They have no power or authority to see your account, to do anything in your account while you're still alive, okay? But the moment you die and that person comes to you, the institution, saying, here's a death certificate, proof, all that, then the institution's allowed to change the name on that account to the person or persons you designated.
It's pretty seamless and it can go pretty quick.
Right. So what happens, that avoids the headache of, as I mentioned, you have all your assets frozen. Well, how do your beneficiaries pay all your estate costs and all that? Well, this gives that person, beneficiaries, immediate access to assets without having to wait through the whole probate process. So these are some strategies. And of course, life insurance policies, 401ks should have beneficiaries. You want to make sure you have your beneficiaries designated in those documents.
So you're typically going to do this with non-retirement accounts.
That's exactly right. That's exactly right. Again, always ask an attorney whether this makes sense or not, because there's different philosophies and approaches on whether this makes sense or not. But it is a strategy that people have employed before they've done their estate plan to at least have something in place.
Well, and that is super important, just to check on these things occasionally over time. I mean, if you get remarried or you get divorced, you need to check on your beneficiaries. You never know, you may have someone as a beneficiary of an IRA or 401k that you didn't even intend to.
Yeah, we've seen that.
A bad thing.
Especially second marriages. We've seen the first wife or the former spouse still be the beneficiary. Like, oh my goodness, you know. So we always encourage you check your estate plan on all dimensions. Okay. So now that you see how this works and some questions to ask your attorney, how do you actually establish an estate plan? Well, engage an estate planning attorney to help you navigate this process. We're going to highly encourage that when you engage an attorney, they do estate planning, and estate planning almost exclusively.
Yeah, that's the focus of their business.
Yeah, because we've seen estate plans as we attorneys, and no disrespect intended, I'm married to one, okay? But I do this and this and this and this, and different parts of law require different specializations. So you want someone who really has a good grasp on estate planning issues and how to manage that for your particular circumstance and in your states where you live. Okay, because different states have different nuances when it comes to estate planning as well. Okay, again, why is this important? Because there's a lot of legal nuances, language that can impact the outcome of your estate plan. Especially if there might be a lot of family members who can question your estate, etc. You want it to be locked down with a good estate plan, written and drafted well by an attorney who knows what they're doing. Okay, so depending again on the complexity of your estate plan, it could be very state specific. If you do have assets, some people have, I have my summer house here or my winter house there. You want to bring that up to an attorney to see if you need to collaborate or if they can do it themselves. But because again, different states have different nuances potentially.
So what would you recommend for someone, let's say younger, that they don't think they really need a will, or they're not willing to pay for an estate planner, an attorney, you know, to spend $1,000 or $2,000 to get a will drafted up? Is there any other option that they could do?
There are other options, and I know where you're going with this. There are people who say, listen, I can go online and do this. I can go to Office Depot and get a will there. That is an option. Do I recommend that? I really don't. Okay, and I say that because, as I mentioned, there's a lot of legalese in these documents that could disqualify. Your office max is probably not going to be state specific. Okay, and this is not an endorsement for attorneys, but I got to give credit to where it's due. This is where an attorney can shine. We actually ran an experiment here in our office. We had someone try to do this on their own, and they're in our office, and they went online, tried to do themselves, and had so many questions. And thankfully we were here to answer a bunch of them. But it is complicated. So if you have no recourse, it's better to have something than nothing.
It says better than nothing. But just a little bit.
yeah, it's just that much, because again, you don't want this messed up. So I'm going to encourage most people who ask me that question to say, save up the money. It's well worth the investment. If it ever comes down to that, it can cost you so much more, as you've learned in this video, if you don't do that well. So that being the case, again, the goal of estate planning is to add additional control and management of your finances, protect your legacy, okay, and preserve your wealth for the heirs. So if you have a good estate plan, you protect your legacy and wealth, which again helps you get to financial freedom and beyond, because this is also next generation depending on where you are on your path to financial freedom. So we hope this helps, and we thank you for watching.